If you are a green card holder planning to travel outside the United States, you need to know about a major legal shift. On June 23rd, 2026, the U.S. Supreme Court handed down a pivotal 6-3 decision in Blanche v. Muk Choi Lau that fundamentally alters how border officials evaluate returning lawful permanent residents, or LPRs. To understand why this ruling is so significant, we have to look at the underlying statute. Under the Immigration and Nationality Act, specifically INA Section 101A13C, a returning green card holder is legally presumed to be an already admitted resident. This gives you massive constitutional protections. If the government wants to strip you of your status while you are inside the U.S., they have to put you in deportation proceedings. In deportation proceedings, the burden of proof rests entirely on the government to prove you are deportable by clear and convincing evidence. However, the law lists 6 specific exceptions where that protection vanishes. If an exception applies, you lose your status as an already admitted resident and are instead classified as an applicant for admission. In other words, you are treated as if you are standing at the border trying to get a green card for the very first time. And the burden of proof shifts entirely to you to prove you deserve to enter. The specific exception at issue in Blanche v. Lau is Clause 5, which says a resident is treated as an applicant for admission if they have committed an offense identified as a crime involving moral turpitude. In this case, the respondent, Mr. Lau, had a pending unresolved criminal charge for selling counterfeit goods when he took a brief trip abroad. When he returned to a U.S. airport, a Customs and Border Protection officer flagged the pending charge, confiscated his physical green card, and paroled him into the country while his status was sorted out. A year later, Mr. Lau pleaded guilty to that charge, and the government used that subsequent conviction to try to deport him as an inadmissible applicant. Mr. Lau fought back, arguing that the border official acted unlawfully because at the exact moment he stood at the airport, he had only been accused of a crime, not convicted. The Second Circuit Court of Appeals agreed with him, ruling that the government must possess clear and convincing evidence at the border that a resident actually committed the crime before stripping them of their automatic right to reentry. But the Supreme Court reversed that ruling. Writing for the majority, Justice Clarence Thomas established a strict 2-step framework. First, at the border, the government can classify a returning resident as an applicant for admission based simply on the commission of the offense, such as an arrest or a pending charge. The officer does not need finalized ironclad proof at the exact moment. Second, the actual evaluation of whether you are truly inadmissible happens later, during a formal hearing before an immigration judge. Crucially, the court ruled that the government can satisfy its burden of proof at that later date using evidence like a subsequent guilty plea or conviction that did not even exist when you were standing at the airport. In short, a conviction that happens after your trip can retroactively justify the border officer's decision to detain you and to take your card. The real-world consequences of this ruling are severe. If a CBP officer triggers this rule, they can immediately confiscate your physical green card and place you into a legal limbo that can drag on for years while your immigration case winds through the courts. During this time, you may face immense difficulty renewing your driver's license, maintaining employment authorization, or traveling outside the country again. Furthermore, because federal immigration law does not recognize most state-level expungements or sealed records, old or dismissed arrests will still appear in federal databases at the port of entry and can trigger intense questioning. Following Blanche v. Lau, international travel carries an elevated risk for any permanent resident with a pending legal matter, a past arrest, or even an expunged record. If you have any history of legal trouble, do not risk the life you have built here by traveling blindly. Call Jarrett and Price today, and we can provide you a confidential, independent analysis of your specific circumstances to ensure your green card and your return home is protected.